Hello, this is Frank Hoyt, President of Midwest Lawyers. We provide professional liability insurance to lawyers throughout Iowa and other Midwestern states. Midwest Lawyers is committed to providing the legal community with the highest quality professional liability coverage combined with the highest level of expertise, advocacy, and service in the marketplace. To us, prevention is just as important as coverage. To that end, we are pleased to provide you with information and legal briefings that are designed to reduce the likelihood of a malpractice claim or ethics issue. We have asked Nick Critelli, past president of the Iowa Bar, to provide you with periodic legal alerts so that you can be aware of significant legal developments that may affect your practice. Nick?
Thanks, Frank. There are few areas of ethics that are more confusing than that which deals with attorney fees. Go beyond the contingent and hourly fee, and it seems that everything suddenly becomes nebulous. Yet in these economic times, clients are demanding economic certainty. Billing based upon the click of a clock, the hourly rate, or the hourly bill just doesn't seem to work anymore. So, to bring some clarity to this subject, I chose the Vilmont case for today's video law brief. It deals with minimum fees and non-refundable fees. So let's brief the case and we'll discuss the lessons learned.
Iowa Supreme Court Attorney Discipline Board versus Vilmont, Friday, April 6th, 2012. Attorney Vilmont agreed to represent Scott Halverson on a criminal matter at an hourly fee of $225 per hour with a minimum fee of $2,500 payable in advance. Vilmont took the $2,500 and placed it in a trust account in accordance with the rules. He then entered an appearance for Halverson in the criminal matter. 14 days later, the criminal charges were dismissed at the request of the state without any involvement on the part of Vilmont. 5 days later, Vilmont closed his file and withdrew the $2,500 from the trust account, but without contemporaneous notice or accounting to Vilmont. Vilmont ignored requests from Halverson for an accounting. When the board filed its complaint and requested an accounting, Vilmont indicated that he had only worked a total of 3.7 hours on the case, one of which was for responding to the request for the accounting. The board charged Vilmont with charging an unreasonable fee in violation of Iowa Rule of Professional Conduct 32, 1.5 sub A, as well as Rule 32, 1.15 sub F, for failing to provide an accounting of the withdrawal. Chief Justice Cady, speaking for the court, held in unequivocal terms that the bottom line is that it is unethical for a lawyer to enter into an unrefundable advance fee contract except in a case involving a general retainer. The court went on to say that we have cautioned that a criminal defense lawyer would be hard-pressed to try to utilize the general retainer exception to charge a minimum, non-refundable fee for representing a defendant in a criminal case. Vilmont's agreement established an hourly fee for services that would be rendered, but imposed a floor of $2,500. This type of fee is prohibited by Court Rule 45.9 sub 2. The court noted that the amount of the fee charged and collected by Vilmont for performing the limited and insignificant services in representing Halverson was unreasonable under the fee factors set out in Rule 32, 1.5 sub A. The Commission found that a reasonable fee for the services rendered by Vilmont would have been $607, or $225 per hour for the 2.7 hours charged, and not the $2,500 minimum that Vilmont charged. Vilmont was given a 30-day suspension.
So, what are the lessons learned? First of all, there's confusion between the terms non-refundable retainer, minimum fee, and flat fee. In the context of Vilmont's case, the Supreme Court always characterized the fee as a non-refundable advanced fee contract. That means that the fee was paid in advance of any work being performed and would not be refunded. This violates two cardinal rules. Number one, it impairs the client's right to discharge the lawyer at any time without penalty. Number two, it compensates a lawyer for doing nothing, In other words, it violates the no work, no pay rule. So applying these rules, let's look at minimum fees, flat fees, special retainers, and general retainers. Now, a minimum fee is a form of flat fee that could be greater than a base amount. Unlike the cap fee, which sets a ceiling, the minimum fee sets a floor. In Iowa, minimum fees are viewed as non-refundable fees and are not allowed. Flat fees, whether lump sum for a total representation or a fixed sum, say per month for all legal services, are called special retainers. Special retainers can either be billed and paid after the fact, after the work has been performed, in which case the payment goes into the lawyer's general account. Or the lawyer can require that funds be paid in advance so that they can be billed against, in which case the funds are deposited in the client's IOLTA trust account. Now notice I said the client's IOLTA trust account. I call it this to emphasize the fact that it is client's funds in the account, not the lawyer's. Should you consider a special retainer? Yes, definitely. Unlike an hourly fee, a specific fee, for a monthly fee for all services performed or periodic fee, is a good way to bring economic certainty to the client. Now, all retainers are presumed to be special retainers. That then brings us to the exception, the general retainer. Now, a general retainer sometimes is known as a conflicts or availability fee. It is either a periodic fee, a monthly fee, or flat fee that simply retains the services of the lawyer. It is not a performance fee. By accepting a general retainer, the lawyer is prevented from representing an opponent, as well as being on call for the needs of the client. These work well in corporate or business settings where the company wants the services of a general counsel. For a fixed or monthly sum, the lawyer acts as the general counsel for the business on any and all matters that may develop. Now, regardless of the form of fee, all fees are subject to the requirement that they be reasonable and that they do not violate the no-pay rule. Okay, a practice pointer. You must always be able to prove that you complied with the no work, no pay rule. And you do this by service logs or time records. A service log reports what you did and when you did it. A time record adds the initial element of time to the log, that is, how long you did it. Now, in those cases where you want the court to assess attorney fees, you must keep time records. Block billing, that is, billing without reference to date, time, and description, is frowned upon and could result in your fee being docked by as much as 25%. Bottom line, keep good records. Now let me close by circling back to the theory that underlies the attorney agreement. We're not talking freedom of contract here. Remember, we are fiduciaries with respect to our clients. We stand in a trust relationship with the client. You know, superior knowledge, vulnerability, disadvantaged client, that type of thing. Consequently, unlike commercial contracts, our contracts are given great scrutiny. When scrutinized, the courts will always look for client freedom. Can the client easily get out of the contract without penalty? Secondly, the court looks at reasonableness. Is the amount of the fee reasonable, regardless of the form? Does the fee violate the no work, no fee rule? Now, this is where your service log and or time records become extremely important. I hope this video brief helps you in your practice. As always, if you have any questions, please feel free to call me at any time. This is Nick Critelli in Des Moines.
Thank you, Nick, for that update. If there are areas of the law that you want covered, please let me know. We're here to serve you. Remember, an ounce of prevention is worth a pound of cure. Thank you on behalf of Midwest Lawyers.